Good morning and welcome back to the eDiscovery Zone, live from the TechLaw Solutions booth at Legal Tech New York. We're here on the morning of day one of TechLaw, or of Tech Show, excuse me. I'm Tom O'Connor, the director of the Gulf Coast Legal Technology Center, based in New Orleans, Louisiana. My partner, as always, is Browning Marean.
Yes, this is, in fact, by the way, Legal Tech, not Tech Show.
Did I? A common mistake. Mistake. And Browning, as I failed to mention, is with DLA Piper in the San Diego office. Our special guest now is Steve Goldstein. Steve or Steven? Doesn't matter? Okay. He's the Director of Practice Support at Squire Sanders in the Cleveland office.
Right.
Welcome, and
thank you.
Thanks for putting up with our mischief-making here today. The buzzword we keep hearing and have been hearing all morning is predictive coding. It's something that people are both interested in and in fact even using on your radar as well.
Oh yes. It's we found it to be a game changer, and have been very fortunate in having the backing from the top levels of the firm to go all in thinking about it and actually putting it into use. It's really been fascinating.
So tell me how that worked. How has that changed your workflow?
Well, first of all, I think you have to think about how people approach it. It wasn't that long ago where we were suggesting that people use keywords, and they would say, no, we have to review every document. We can't rely on keywords. In the old days, in like 2006,
right.
Even then, keywords were hard. But a couple things have really happened, and it's making that sort of mindset accelerate towards this. I think certainly the global economy situation of 2008 plays a part. But there's also been sort of concurrent with that, corporations are asking for more value out of their firms as well. The ACC Corporate Challenge, and we sort of embrace that as well. Both the economic realities and the direct message from corporations, at least had the leadership of our firm thinking about how are we doing things and are we providing the best value, and is our business model correct? That's a huge step towards getting attorneys to listen to the tech guy, when you have that backing.
Well, I was going to ask that question, in the John Henry versus the steam drill. Obviously, you're trying to promote the steam drill, and setting aside your top management, how's the rank and file? Are they embracing this? Are they bringing skepticism to it? And how do you defuse that skepticism?
Well, I think there's a little bit of skepticism, but then we point out some realities. We, along with other law firms, let a bunch of people go in 2009. As far as I can tell, they're not coming back by the dozens. Sure, little by little, we're staffing back up, but those people don't exist. If we had to staff a large review like in the Enron days, I don't think we could actually do it right now with the people we have. So we're already going to be giving that work to contract staffing agencies. So that barrier is sort of gone. We then show them, how fast this will go in terms of timing. We can really accelerate the process of getting through the discovery. We point out that they're going to learn more earlier in the process. So whereas the traditional way of slogging through documents in a linear fashion, the key documents would come to the decision makers, to the partners, months down the road.
Right.
We're finding this is happening in the first few days.
Interesting.
So when you point out both the fact that it's not an economic problem for the firm really anymore, it is an economic problem still for our clients, and there's certainly some cost savings here. But it's a better process, and it's a process that we've repeated numerous times, and it's a process I think that has growing acceptance within the courts, and all these combine to get through those barriers.
Do you have in mind a metric for the extent to which you are able to keep documents from going into the review room by the use of predictive coding? Sort of a convoluted question, but it really relates to, I know it costs some money to use the predictive coding tool,
right,
but the savings come down the line.
Right.
Are you finding that to be true?
Oh, yeah. That's sort of the big shift. We used to think about the cost of a project so vendor A wants to charge X amount of hundreds of dollars per gigabyte, and vendor B wants this, and so B is cheaper. Well, while we're putting that pencil to paper, going through that process, the partner typically is saying, I think we can do the discovery for $70,000, right? And then they learn that that's not even going to cover the first month of discovery. And so that was sort of a battle we had in the last 5 to 10 years. We are now squarely predicting the costs of the review. We almost don't care about the cost of the processing, because it's a rounding error when you think about the cost of law firm attorneys at $300 an hour going through this for a few months. So absolutely, we have models to suggest that if the volume shrinks by this much, and if we review it through these efficient processes using these tools, then we're going to save that much money from other ways.
You mentioned the client and the cost factors, of course, but are the clients getting involved with any of that front end paring down or culling of the data?
I think where we see a lot of client involvement is the buy-in to doing the process this way. We certainly do need their input in order to train these systems, and it doesn't matter which predictive coding tool you subscribe to. I think they probably all do reflect the input that they get. So if you have garbage in, you probably will get garbage out. And so we do have a lot of client involvement at the front end to really understand the matter to a level where it can be trained properly. By extension of that, we have been able to successfully engage really senior level attorneys in the front end process.
Okay.
So we're not taking a second year associate and sending them on their way. We put them in a room with a partner, with a senior associate, for a number of hours to sort of get that thinking in line, and then we let them complete the training process. And that has been really a fascinating approach as well.
Well, in fact, a question, given your experience, have you had any situations, without going into client confidential things, where courts have really questioned predictive coding and said, well, how do we know? How are you vetting that process?
I mean, it's certainly a concern, and I think we talked a bit about the acceptance earlier. One big piece is to tell them, the attorneys, the client, that while we haven't had to do it yet, and frankly I don't think anyone has had to do it yet, we believe that we could survive a court challenge, and there's some of the more nerdy attorneys
Why are you looking this way? Look that way.
I think there are some amongst us that would welcome that challenge and look forward to it, particularly in the right jurisdiction with the right judge. We believe that we could defend our process, and that we can show the steps that were taken to train it correctly, to improve the model along the way, to sample the results, to really validate the output of the system, to show that it is as good, if not better, than a human team would have done.
Well, when you go back to that Blair and Marean study of 20, 30 years now, I think it's really appalling, the vagaries that you get with human review. I think Judge Peck's article a couple of months ago, where he talks about predictive coding, are great steps in encouraging people, in fact, to use it. So we've only got a couple of minutes left, but we are here at Legal Tech. What do you hope to find here?
It's a good question. After a decade of this, I'm still overwhelmed.
Yes.
And being that you've caught me in the first 15 minutes of the show, it's sort of washing over me. But I expect to find a lot of vendors pitching generic predictive coding, and I expect to probably find various levels of competency. And I hope to sort of be able to weed out who really gets it and who is just selling it without perhaps the foundation.
Right.
I mean, we're fortunate that we have a process. We have partners that we're sort of got a very nice workflow, These things don't last forever, and so it's important that we keep up with trends and know who's out there, and hopefully we'll shake it out.
One other question for you. We were talking with another fellow recently about National E-Discovery Council, and are you finding that now that you've built this in-house skill and competence that while you may not be trial counsel, nevertheless organizations are turning to you to do the e-discovery piece?
Yes. We have a couple of big ones, in fact, that I can't publicly tell you about yet, but that has been experienced. That these big corporations, they have dozens of inner circle, panel, whatever you want to call it, and they're all doing things differently.
Yes.
And it's probably, if it hasn't hurt them, it will hurt them. To do a process one way with one law firm, do it entirely different another way, does not help their defensibility probably for times down the road. So we're in fact talking to a number of clients about helping to train their preferred law firms and to get everybody sort of approaching things uniformly, so that preservation and collection and the processing and the decisions made are sort of all in line. And it's a challenge.
Right.
It's really a hard thing to do, and it's really remarkable to see how these big companies sometimes have the same challenges we have at a big law firm. I mean, we have some hundred number of partners, and they're empowered to do whatever they like. And getting them all to march in the same direction is not easy. And I think within a corporation you have a little bit of that as well.
Well, when you figure out the harmonization, would you please call me?
I will. We can sell it.
That's right. There's a strong market for that knowledge base. Absolutely. Well, thanks once again for stopping by. Our special guest has been Stephen Goldstein, Director of Practice Support at Squire Sanders in Cleveland, Ohio. We're going to let him go, as he said, onto the first wave while he's still fresh of the exhibit hall here at Legal Tech New York. And we will be signing off for now from the e-Discovery Zone.